Good morning, ladies and gentlemen. So this morning, we are going to focus on the Foreign Subsidies Regulation, a new piece of legislation at the European Union level. State aid has been part of the European Union acquis since the start of the treaties, which in principle prohibits state aid at the European Union level, unless it is in the European interest, as you all know. But how to deal with the fact that many countries give state aid on an uncontrolled or a less controlled basis than the European Union, which obviously creates a very unlevel playing field. So the EU has now introduced a piece of legislation called the Foreign Subsidies Regulation that enables us to address this under certain circumstances on certain occasions. And we have the enormous fortune to have Christof Schoser with us today from the European Commission, who is the head of the task force, the Foreign Subsidies Regulation Task Force, who has the enviable job of implementing this highly complex, procedurally and substantively, piece of legislation in practice, and then kicking off its implementation. This will be a huge challenge and will have enormous consequence for, well, all industry, including the energy industry. And so, Christof, we're very grateful that you've taken the time to join here, and I'd like to join us today. After Christof has spoken, Ilaria and Marzia from the Florence School of Regulation will pose a series of questions and open a debate. So, Christof, thank you very much indeed for being here. The floor is yours.
Thanks very much, Christopher. And yeah, hello and welcome to this presentation. So I would like to kick off by presenting you the main features of this new regulation. And then I understand, yeah, we can go into more detail during the discussion. So as Christopher mentioned, and as you all will know, there is a state aid control in the EU that has existed for many decades and has well, evolved over time, but become, let's say, more sophisticated in application. But there hasn't really been any control of foreign subsidies in the sense of subsidies granted by non-EU governments that may have an impact on business activity on the EU internal market. If we switch to the next slides, I can do it maybe even myself. No, thank you. So well, the question was, of course, to design legislation that would not prevent investment flows and investment within the EU would not undermine trade flows, so that only the subsidies granted by non-EU governments that are really distortive would be targeted by this instrument. And also, I think a big request by the business community, obviously, was to avoid excessive administrative burden in enforcing such a regulation. And the regulation that was now politically agreed just before the summer, we think complies with these ideas. It defines very high thresholds for notification, and it aligns to the extent possible to existing legal instruments, and I will come to that in a bit more detail later on. Another obvious concern was that any new legislation may be in breach of the EU's international obligations under the WTO rules, because under the WTO there are, to some extent, rules relating to subsidies, and there are more general principles, such as the non-discrimination principle, basically that you can't treat companies from other countries worse than the companies that are basically in your own country. And there are, well, the rules under the WTO, which refer to subsidies, are, however, quite limited. They basically relate to the production of goods in third countries, to take the relevant example for the EU, which then are physically imported into the EU. So, and there is the agreement on subsidies and countervailing measures that is the main piece of legislation in this area. And as that is international law, based on a multilateral framework, the EU could not come forward with legislation overlapping or even contradicting with those existing rules. We move on to the next slide. So based on these general principles to design legislation, well, first the Commission in last year proposed a regulation, which then was agreed earlier this year. And here this slide presents the main steps of how such a foreign subsidies control will be carried out. Just to first give an overview, basically the regulation gives a definition of what is a foreign subsidy. It then defines a process, so to some extent a notification is necessary, but in most other cases the Commission can act on its own initiative and can only act on its own initiative. The legislation also defines the legal test to assess subsidies, to say when they are actually distortive and problematic, obviously then. It gives details about the balancing tests, whose objective is to also take into account potentially positive effects of foreign subsidies. And finally, the legislation proposes remedies to correct the distortions caused by foreign subsidies. If we go into more detail, and to the next slide, please. Next slide. So the first of these building blocks is what is the definition actually of a foreign subsidy? And here, for those who know state aid control a bit better, they will recognize elements of, even if they have slightly different names here in this piece of legislation. So the first condition is a financial contribution in the state aid world that would correspond to a state contribution to state resources that is then provided by a third country. So behind is the concept of attributability, and state aid that's imputability, and actually confers a benefit to the beneficiary. So in state aid, that would be an economic advantage. And it needs to be selective, so that if it's a benefit, kind of a very general tax measure, for example, that applies to all companies, then it wouldn't be selective and it wouldn't constitute a subsidy, just like a state aid wouldn't exist for any measure that is not selective. And the examples given are those that are also often found in the state aid world. So there are many more forms of subsidies than just direct grants. It can include interest-free loans, unlimited state guarantees, or capital injections at favorable conditions, so not at market conditions. We move on, please. So this is now about the procedures. I mentioned in the beginning, there is the need to notify, but that notification requirement is quite limited, only to very large transactions. It's transactions above where the target company in an acquisition has a volume of more than 500 million. Well, you see it in the box on the right, and in the public procurement procedure where the tender value is about 250 million. And for the rest, there's this general investigation tool where the Commission on its own initiative can start a case if there's a suspicion of foreign subsidy influencing the internal market. It's the Commission that enforces the regulation, so mirroring state aid control, where it's also the Commission only that has the competence to control state aid. Member states are involved in the decision-making process through an advisory procedure in particular. The ex officio review can, in principle, look into all economic activities in the EU, just like state aid in principle applies across the board. So it's not limited to any strategic sector or of any sector of any particular kind. The regulation includes a number of tools to try to gather information. There's also a possibility to carry out market investigations. I think we are aware that a particular challenge will be to enforce the regulation to get the necessary information, as much of the information that is relevant is actually outside the EU, as the measures investigated are subsidies granted by third countries. We move on, please. Well, here the thresholds I mentioned that are relevant for the notification. I mean, just to give a comparison, the threshold for the turnover of the EU target here under the foreign subsidies regulation is the double of what it is under the merger regulation, so that we expect a sufficiently lower number of transactions that need to be notified. Something worth mentioning is a kind of innovative approach, the so-called ad hoc notifications. Just because the notification thresholds are so high, it was felt that there may be problematic subsidized transactions below those thresholds, and in those cases, the Commission can actually also ask for a notification on an ad hoc basis, and that also applies to the public procurement module of the regulation. And the notifications, just like in the merger review or in the state aid world, have a suspensive effect. Move on, please. Well, more about the assessment of the distortion. So the legal standard, it's well, basically has two legs to see whether the competitive position of the undertaking is improved, and then also whether that affects negatively the competition on the internal market. The regulation gives a number of indicators on how such a distortion can be measured, and it defines a number of categories of subsidies that where there's almost this type of presumption that they would be distortive. For example, if it's found that a subsidy really directly helps a company to acquire an EU target company, that would fall into one of these categories, which would make it difficult to justify any such subsidy. There are thresholds also for smaller subsidies to try to really focus on the bigger subsidies. So there is a 4 million threshold under which foreign subsidies are unlikely to be considered distortive, and 200,000, just like in the state of the world, hard de minimis threshold. Move on, please. Then we come to the balancing test. I think the rationale behind that is that just like in the EU, not all state aid is incompatible. But quite to the contrary, in many cases it's found to be compatible. There also needs to be a consideration whether a foreign subsidy has a positive effect. It may be often an unintended positive effect that the non-EU governments may not typically intend to create a positive effect on the EU internal market. But especially in the area of climate change, for example, where we have cross-border spillovers, kind of a positive action in a third country may also have a positive effect on the EU internal market. So these positive effects need to be considered, and they may actually also be found to outweigh the negative effects, which would make that subsidy could be cleared, let's say. And there would be no need to impose any redressive measures that remedy the distortion. On the other hand, if the negative effects still prevail, the Commission has a list of potential remedies in the regulation that it could use, and that moves us to the next slide, please. So the regulation lists a number of redressive measures. They again have been inspired by redressive measures that have been used in the state aid world, and there's actually quite a broad range of measures when you think about rescue and restructuring cases or banking cases. So it's not limited to the typical recovery that is done in state aid cases, but it's, for example, rescue and restructuring cases in the state aid world, there have been structural remedies or even behavioral remedies And here that's kind of a toolbox that has also been now proposed for the foreign subsidy regulation. I think ultimately, in the case of a very distorted subsidized acquisition, the Commission can even prohibit the transaction on the basis that the subsidy distorted the acquisition process and that the acquisition really had a strong distortive effect on the internal market. We move on, please. I mean, to already come to the end of the presentation, I think it's worth mentioning how that regulation has evolved in the political process, also to see where the focus has been of the Parliament and the Council. I think the core of what you've seen has been largely unchanged during the legislative process, but there was a strong push, in particular by the Parliament, actually, to make sure that the foreign subsidies regulation doesn't undermine the efforts of the EU trade policy to conclude multilateral agreements, or at least bilateral agreements in the trade area. So the final political compromise on the regulation included declarations, basically stating and repeating that the Commission and the institutions, the EU as a whole, remain committed to an open and rule-based multilateral trading system, and in a way that is still considered a first best option. It's just as the negotiations under the WTO are quite difficult these days. I think there was also agreement that one cannot wait for the WTO to solve the issue of subsidies, and that this doesn't undermine the reason to actually propose the foreign subsidy regulation. And if we move to the next slide, please. I think an important point also during the negotiations was that many, and I think that in particular member states, felt that more guidance and guidelines was necessary on key concepts of the regulation. As I mentioned, some of the concepts are borrowed from the state aid world, some are borrowed from the trade world, for example, the notion of financial contribution. But in this particular context, they may take on a specific meaning, and some terms have been coined, particularly now for the foreign subsidies regulation, just like the balancing test, which I tried to explain before. So the regulation also obliges the Commission to come forward with guidelines on some key concepts. There is fortunately some time to develop those guidelines, as some experience is needed on how these concepts can be applied, as well. The world of foreign subsidies and subsidies generally is not sufficiently transparent today, let's say. So it's difficult to know now beforehand exactly what to expect, what kind of notifications, what kinds of problems we will encounter, and on the basis of this, I think the guidelines and the case practice have to evolve. Next slide, but I think we had, well, yeah, is the last slide, just the milestones of this process. So the last step that took place was the political agreement between the institutions on this regulation. It will be formally adopted by the EU Parliament tomorrow, actually, and I think on the 28th of November it will be adopted by the Council, and there will be a signature in December. So we are very close to the formal approval of that legislation. Once it's published in the official journal, it will take another 6 months before it actually starts to become applicable. Though we're talking therefore about mid next year, and there's an additional 3 months delay for the notification requirement to kick in, so that companies also have the chance to prepare. I should mention, at the moment we're working on an implementing regulation that includes notification forms. That should clarify more certain procedures relevant here for the notifications, but also for access to file. And I think very importantly is the notification form that gives a level of detail and the information that companies need to submit if they fall under either the public procurement notification obligation or the one for concentrations. And I think that closes this presentation. Yeah, I'm looking forward to the discussion.
Thank you, Christof. That was very clear and really, really helpful. Ilaria and Marzia, I pass the floor to you for the first set of questions.
Hey, great. Yes, thank you very much for a very, very interesting presentation. This is by definition a new subject also for us. So I think with our questions, we would like to maybe understand better this new regulation. So first of all, if you could please elaborate a little bit more on which companies or sectors the regulation will target. Obviously, we are all aware of the dramatic times that we are living because of the invasion of Ukraine from Russia, and therefore we can all see every day how energy has become the absolute top priority, also in the EU policymaking agenda. Particularly considering, for example, this quite well-known gas dual pricing that Russia is applying, the practice that by which countries like Russia, for example, sell their gas at a lower price domestically, and then this obviously gives an edge to Russian fertilizers companies over European players. And there will be other examples, perhaps in the basic industries, with metal companies struggling to compete with state-backed Chinese companies selling their excess production on European markets at prices that are literally impossible to compete with. What would be the selection criteria and priority in terms of sectors for these EU investigations to be carried out? Are these typical examples that would be pursued?
Yeah, good and difficult questions to start with. I think first to your last question, are there any particular sectors targeted? I think the regulation is neutral on sectors. I think as I think said during the presentation, in principle, there is no preference given to any particular sectors. There was a discussion whether it should focus particularly on strategic sectors, but all this was dropped also in view of the FDI screening regulation, whose purpose is precisely security and public order and look at strategic sectors. So there is already an instrument that has been transposed by most member states to target strategic sectors. While the foreign subsidies regulation is more economic control, a level playing field in economic terms. So that's the idea. But of course, there may be more problems in some sectors than in others. We don't know yet, and I think that will be one of the first tasks once the regulation is actually applicable. To define on which areas to focus. There have been reports by the OECD, for example, into certain sectors that may be relevant. It may be high-tech sectors, but it may also be traditional sectors. So I think for us, it's early days. We don't know yet exactly, but I think the criterion to choose sectors, if we have the possibility to set priorities, will be economic ones and not let's say strategic ones, like that would be for the FDI screening regulation. The other question more specifically on dual pricing, I think I also would have reserved my position. I think whether this would be considered a subsidy and that would actually fall under the EU foreign subsidies regulation, I think we would need to have more detail. I think I did say in my presentation, and that's true, that the notion of subsidy, just as the notion of state aid, is quite a broad one. So I don't exclude that such price support constitutes a subsidy, but also knowing that under the EU stated rules, the answer is not easy for this kind of price control, whether that is considered a state aid or not. So I think that really depends on the details of the measure. But potentially, if it's a subsidy, then it could be something that could be looked into. But of course, then it's not enough for it to be a subsidy then to be relevant under the regulation, because then we also have to show that it actually influences somehow the internal market. That would be the next step to assess.
I see. Thank you very much.
Marzia?
Yes, sorry.
This one's for you.
Yeah. Hi. Thank you for the presentation. It was really interesting. And I see that you presented quite a few slides on tools and procedures and, definition of subsidies, which when I look into it before, coming here and listening you speaking, the definition of what constitutes subsidies is a bit broad, and also it might be difficult to detect foreign subsidies. So I was wondering if you're already beginning to develop approaches to streamline the information collection process so that it maximizes transparency and minimizes the burden for the Commission and the companies involved.
Yes, I think this is actually something we're doing just now to try to be more specific about what is relevant information that companies need to submit. And most notably, that's relevant for the notifications where companies, it's the burden is in a way on companies to submit relevant information, but for them to be able to do this, we need to tell them, of course, what is relevant. So that's basically the work we're just doing on the notification form. So let's say from the outside, it will look very much like a notification form under the EU merger regulation. But of course, the substance is to a large extent different, as we are interested less in what the merger is about and how the merger as such and the acquisition of a company or the creation of a joint venture actually changes the market, but rather the focus is if the acquisition process has been distorted by a subsidy and what kind of subsidies or rather financial contributions companies have received in the last 3 years before they acquired an EU target company. So the key notion there, I think that's important to emphasize, is this notion of financial contribution, because we don't ask companies to notify subsidies. As you may remember from one slide, well, a financial contribution is just one element of subsidy. No, it needs to have a benefit attributable to the state. It needs to be selective. But that kind of assessment, we don't want the companies to carry out themselves, as I think would also be a challenge for non-EU companies not being familiar with state aid rules, for example, to carry out such an assessment. So it was important, in a way, it should alleviate companies just have to notify financial contributions. This being said, the notion is very broad, and I think also it captures a number of support measures or interactions with the state that in the end do not turn out to be subsidies. But that is then the kind of assessment that the Commission will have to do. And yeah, with a notification form, we're trying to be as specific as possible to give guidance to companies what is the relevant information they need to submit.
Can I just follow up on that, Christof? Because I was just looking at it and I was imagining that I was Ørsted or Enel or Iberdrola or one of these huge utilities. And they would have a procurement activity or joint venture within the thresholds, and this industry is a really big one. So those thresholds are quite big, but in fact, in the energy industry, they're not that big at all. And these companies are active in renewables in pretty much every country in the world nowadays. And presumably in every single country in the world, they have subsidy regimes or support regimes or tax breaks or government guarantees. So if they would do a joint venture in Hungary, for example, would they have to notify all the subsidies they received everywhere in the world, irrespective of how relevant it is? And how are you going to balance that need in order to make it manageable with a need to make sure you actually capture all the relevant information from a Chinese firm or a, I don't know, any other non-EU firm that is really the focus of the activity?
Yeah, that's actually just the question we're working on, how to focus the notification requirement, or at least the information that needs to be submitted, more on what is relevant. If there can be any limitation in terms of, well, any quantitative limitation, or on substance, to link it to the transaction that is being looked at. The challenge is, of course, also the more you limit it, the more you open the door for circumvention, or you may simply fail to capture what is relevant. But that's a bit what we hope to do with the notification form. If you just look now at the regulation as such, I think your first statement is correct, that all financial contributions received outside the EU are potentially irrelevant, and fall in the scope of the regulation. If well, we hope to make it more focused than in the notification form.
Do you think you're going to get notifications like you see in American crime movie things, with the trial, where one side gives you 13 lorry loads of information in order to hide the one piece of paper they're looking for? Will you be able to avoid that?
Let's see. The challenge is up.
Okay. Sorry, Ilaria, I went off on a tangent. I'll give the floor back to you.
It was actually a very, very good question, I think. Well, maybe about potential criticism. Sorry to open this box, but while we were preparing this debate, we read that some international, some third countries questioned whether this new instrument would not violate international obligations. You already mentioned the WTO in your presentation, but particularly because it would impose a different standard for the foreign companies compared to the EU companies. So basically adding more administrative burden to them. So what would be your reflection here, considering also the new global energy geopolitical framework, which is something that we have to take into account, and on which this could have an impact on the relations with these other countries?
I mean, the basic principle is that we could not be stricter in the assessment of foreign subsidies than what we are for the assessment of state aid. And I think that's particularly relevant in the energy area, where in the EU, I mean, for good reason, I think at the moment there are subsidies. Well, there've been subsidies over the past years, of course, to enable the greening of the economy, and to reduce the CO2 emissions, avoid climate change. So that's been there for a long time, and I think we can't and shouldn't be stricter with third country subsidies than with our own EU subsidies in this respect. But of course, at the moment, there's the additional crisis, as you mentioned before, the Russians' invasion of Ukraine, that has created also in other areas of the energy market, if not all areas of the energy market, a stress situation, and where governments hand out subsidies to mitigate that effect. But that effect may also be felt, or is also felt, outside the EU. I think in that respect, it is, we hope, an exceptional situation, but so we wouldn't be stricter with third countries than we are with our own measures.
So,
Ilaria?
Yep. Sorry, Christopher.
Go ahead, Marzia.
Okay, so I just have like one curiosity, because you mentioned guidelines on how to apply, subsidies and all of that. So are those going to be sector specific ones, or just like general broad guidelines?
I mean, the guidelines that are mentioned in the legislation, so in the regulation, they're about certain concepts. And in one case, well, procedure. So criteria when the Commission can start an ad hoc notification. So that's more procedural, even though I think substantive reasons should be given if the Commission decides to start an ad hoc notification process. And about the concepts of distortion and balancing. But that's kind of the legal obligation. I think ultimately our objective will be to also give more guidance, let's say, based on the experience that we gather. Let's imagine if it's possible to give also exemptions. I think ideally, like in the state aid world, there's the general block exemption regulation that exempts member states from notifying certain types of aid if they comply with certain criteria. I think we should try to have the objective to have something similar sooner or later for the foreign subsidies, to give guidance on when there is a need to notify and when they're not problematic, even for ex officio cases that third countries know when designing subsidy schemes, there may be certain things that risk being problematic with us. It's these subsidies which are already mentioned in the categories, but maybe we can define more categories. Maybe we can exempt certain companies that don't pursue commercial or strategic objectives. Maybe we can exempt or give more guidance on certain types of subsidies. So I think I see this legal obligation on coming forward with subsidy guidelines just on concept as a first step. I think ultimately the objective will be to develop more guidance than in every possible way.
In terms of renewables, I've heard it said that the EU won the race in order to increase the amount of renewable energy investment, but lost the race of actually manufacturing the PV panels and creating the industry in order to do it. And it's widely, I was going to say accepted, considered that the Chinese industry got a huge benefit from state ownership, state guarantees when they were dominating the PV market and closing down the European one 20 years ago. The regulation focuses on procurement and it focuses on M&A. But of course, there's other ways in which to use subsidies unfairly. A Chinese company, I'm using China as an example, I'm not wishing to, a foreign company can set a subsidiary in Europe and use the advantageous terms they have in simply giving better trading conditions than Europeans because of their state subsidies they receive at home. So it's not a merger and acquisition, and it's not a tender as such. It's simply they are selling it cheaper than Europeans through a European company, subsidiary, because of the state subsidies that they get, the tax breaks, the state ownership, whatever it may be. And, the Chinese industry has more or less taken the solar panel, the PV panel, and now we see more and more windmills coming from China, and electrolyzers is going to be the next battleground.
Yes.
Can this regulation be used in order to actually address this problem, not the M&A problem, if you like, but I can sell it cheaper than you because I've got a tax break or a state guarantee, in order to give protection to the European industry and create a level playing field in that way? Or do you just have to do that under dumping, which has shown itself to be a very blunt instrument?
Well, it will depend on the details of the case. No, it's not easy to reply to in abstract. But I think from the examples you give, they seem to fall more under the existing rules under the WTO, and that the trade defense instruments would have to be applied, because what is carved out of the foreign subsidies regulation is this scenario, and I think that applies mainly to solar panels, that they're produced in the third country, and arguably they're more cheaply because the companies producing them, they get more state support. No, that's kind of the scenario we're looking at. And then they sell them cheaply into the EU. But that kind of scenario is already covered by the trade defense instruments. So that couldn't be tackled under the foreign subsidies regulation. I think companies have come, associations have come and complained and said, well, now you have developing the foreign subsidies regulation, let's try to correct what doesn't seem to work under the trade defense instruments or the anti-subsidy regulation. And I have, well, I cannot judge if the trade defense instruments are not functioning. I think they are being applied, but so many people argue they're not sufficiently effective. But the foreign subsidies regulation is not there to correct that problem. I think we need to be clear, if there's a problem in that area, it needs to be tackled with the existing instruments which cover that. So the foreign subsidy regulation wouldn't and will not apply to the import of products that may have been produced with subsidies in the third country, like I think your example of the solar panels and probably then parts of wind turbines would suggest.
Thanks. Ilaria, sorry, I butted in.
No, I think, well, personally, I have no more questions, but I see there are a few in the chats that we have 3 questions. Maybe Christopher, if you want to take them. And
go ahead, Ilaria.
I just realized that Foreign Subsidies Regulation and Florence School of Regulation have the same acronym. So I was a bit puzzled at some point. Let's be careful not to misunderstand. So, well, Christoph, see if you are in the position to reply to these questions. The Foreign Subsidies Regulation does not request that the financial contribution stems from state resources. Does that mean that a case similar to Preußen Electra occurring abroad may be caught by the Foreign Subsidies Regulation?
Well, I think the notion, well, it's true that we don't, the notion state resources is not mentioned. And I think also to distinguish it a bit from the state aid world and not to go into the pitfalls of much of what has been discussed and changed over the years in the state aid world. But the notion, well, a foreign subsidy, one part of the element of a foreign subsidy is that it needs to be attributed to a third country. Well, how this can be interpreted, I think, is not, well, will evolve with case practice, and whether a Preußen Electra scenario is covered or not. And as you may know, the jurisprudence on that has also changed in recent years again. I think we need to look again at the specificity of the case and of the measure looked at. But I think that the elements that there needs to be a financial contribution and that needs to be attributable to the third country are very similar to what exists in the state aid world.
Okay, clear, thanks. There is a reference to another specific case, Court of Justice striking down a case against Luxembourg's arrangement with car maker Fiat. I don't know if this rings a bell to you. It's this was about subsidy considered a preferential tax treatment. So how does this sentence actually ruling that special tax breaks are not hidden subsidies impact on the foreign subsidy definition?
Well, it's a court judgment that came out yesterday.
Ah, okay.
I haven't had time to read it. I read about it in the press, but I wouldn't feel comfortable to give an interpretation now off the cuff of what this court judgment means in these tax cases, which are, well, as you know, are very complicated tax cases and very innovative cases. But I mean, it's true that the court annulled the ruling by the lower court, which had and at the same time annulling the commission decision with this. But I think not only me, I think we as
it's too early.
Combination need a bit of time.
I guess you can turn that question to the following, which is, will the regulation necessarily take the same interpretation to tax breaks as the state aid rules do?
That's the $1 million question. No, I think
$1 billion.
Well, probably indeed, yeah. No, I think the tax area in the state aid world is, I think, for me, the most difficult area when it comes to assessing whether there is a state aid or not, and whether the principle of selectivity has been complied with or not, and benefit. So if it's up to me, it may not be the first cases that we should look into, as it's a very complicated area within the EU. But I think all these to take the positive side of it, I think the court judgments that have been given over the past years in these rather innovative tax planning cases give more and more clarity on how we in the EU ourselves assess tax measures, which has been an area that's evolved very much. And I would think once that there's stabilized and there's a common reading on what we do in the EU, we can try to apply the same reasoning also for the foreign subsidies regulation. But my concern is that we don't know yet exactly which way we're going within the EU. And I think as long as we don't know, it's maybe not the first cases we should take up under the foreign subsidies regulation.
Okay, Marzia, Ilaria, do you have any additional questions? I personally don't. I think Christof has been extraordinarily clear.
I would agree, and also he managed to raise our interest on a subject that, of course, we will have to study more in details and follow. But it's absolutely interesting. Thank you very much, Christof. Yep. Very clear presentation.
Yeah. Me too. I don't have any questions. Thank you.
Thank you, Marzia. Christof, thank you very much indeed. That was an absolutely brilliant presentation. Really, really loved it. Thank you very much. And I'll close the session on that.